question is how to navigate the legal landscape in digital assets. And also just a little note, we have Josh, she's been with us since day one, 7th edition, 7th time with us, so that's amazing. She just flew in from New York.
Today,
Philadelphia. Fantastic to see you all. And Alireza, the word is yours.
So, good morning, everyone. It's Alireza here. So we're going to have the honor to kick off the first panel today. So let me just sit down to see you all. So, good. The first panel, before we talk about the first panel, just a little bit brief out and just think about what's happening right now. So we see it all in the media. Celsius, Coinbase, algorithmic stablecoins. So what's going on? That's a question right now, and I can just tell you from a lawyer perspective, because I'm a lawyer, I'm a German lawyer. All of that is happening because of actually two things. One is the lack of understanding what is really happening. I mean, Celsius. I was talking about Celsius like 1.5 years ago with German banks and those who did this crypto lending, and they were asking me, hey, Alireza, what is this crypto lending? Is it good? Is it bad? Can we do money with that? And I was saying, I don't really know myself, so I have to look into the contracts, what is really happening in crypto lending, because crypto lending, it sounds like you lend someone your crypto and you get money for that. But actually, if you look really in the documentation of Celsius, you give your crypto away to a third party who you don't know, you don't have any insurance, you don't have anything, and this person is taking your crypto, doing some investments with it, highly speculative investments, and then you hope to get some interest back. The interest is not really matching the risk in the end of the day, and then if the default is happening, you are right now in this situation, no one can really help you, because if you look at the typical capital market, the fiat capital market, at least in the European Economic Area, we have some regulation where it says that up to 100,000 euro, your deposit should be protected. Something like this does not exist with crypto. So well, the first thing is a lack of understanding, and the lack of understanding brings us to over-regulation or no regulation at all. And we are exactly in this position where people come and say, okay, let's ban proof of work blockchain, which is nonsense in my opinion. It's not really working. And on the other hand, like players like Celsius or players who are in jurisdictions where we have no regulation at all can do whatever they want to do, and no one really understands what's going on. So, and I believe to have a proper functioning of the crypto industry, we need to have a better understanding of the instruments, of the business. We need a better understanding of the regulation, and we need a proper infrastructure. And I think today's panel will show you how the infrastructure for the crypto assets industry could look like around the globe. And I'm very happy that we can discuss today about standardization, so ISIN and other standardization numbers of crypto assets. We're going to talk about patents. We're going to look at the animal in the closet, which is like the travel rule or the know your transaction compliance rules, which are recommended by the FATF. We are going to look at what is really happening in the US from a legal perspective, from a regulator perspective. And we're also going to look what is happening in the crypto hotspot Liechtenstein. So this said, I would like to give the word to the speakers, and I would like to introduce each of you by connecting the dots. So I was now talking about the topics, and please, you start by giving a small intro to yourself and explaining to the audience how these topics I just explained fits to you. And I would say ladies first. Josh, please start.
Hi, thanks. It's a pleasure to be here. Thank you guys for having me. I'm Josh Klayman. I'm U.S. Head of FinTech and Head of Blockchain and Digital Assets at the global law firm Linklaters. And I'm also on the board of the Wall Street Blockchain Alliance and of Wharton's Cypher Accelerator. I'm also on the board of Diversity in Blockchain. So I've been in the space for a while, and this is my lifeblood, I guess, my passion. So how this relates to what I work on? Well, I've been working on these matters directly, actually, including with, and I can't obviously say anything privileged, but certainly with asset managers who have gotten margin calls as a result of some of the challenges and the depegging of, for example, staked ETH to ETH and various things like that. So I think, should I build on what you said? Is that the best way to go, or are we
I think we just go to the next one, and then we will have a dialogue rather than a monologue, so to
Perfect.
see how we can put these small pieces together. And talking about US, as I said, those of you who are familiar with the crypto industry know why I said Liechtenstein is the place to be. So Thomas, explain us a little bit.
Okay, my name is Thomas Nägele. I'm a lawyer from Liechtenstein as well. I started to code software for about 10 years before I became a lawyer. I discovered Bitcoin in 2011. I started my PhD in 2013 about the legal nature of Bitcoin. So in 2016, I was invited by the Liechtenstein government to join the work group to think about legislation, which is now in force since 1st of January 2020. It's called the Liechtenstein Blockchain Act. The real title is TVDG. So if anybody is interested to hear more about that, I'm happy to talk to you the next 2 days. My lifeblood is blockchain. It always was since I started my law firm. We are flooded with requests. Liechtenstein is in the heart of Europe. We have a very comprehensive legislation, and to connect the dots to your intro, Alireza, these are exactly the things which we try to address in legislation, right? And I think it is crucial to first of all understand what blockchain is capable of and what it is not capable of. And the question is, if you regulate intermediaries or if you let the technology work itself, because it is possible to solve these issues, right? But like these things which are happening currently, right? These don't come unexpected. I mean, we still have the same demand. We still want to do the same things. I want to get a loan to finance something, and the other guy is getting me credit, wants to have some interest, right? But the problem is how you structure that. And that there are ways of doing that in a new way, but if you don't do it in a new way, and this is done in the same way as it was for always, right? We would have in the traditional world very intensive regulation for good reason. So I'm happy to touch base on that if that is of interest later.
We will definitely do that, and I can see on your lab your publication you brought with you. It's your PhD publication, right, about crypto?
Yes, it's about the legal nature of token. I also wrote another book about the secondary market for security token. It's actually quite interesting because what we see now in Europe with the MiCA, the Market of Crypto Assets Regulation, that will be my second book, which I published last year. And the first one was published 4 months before the European Commission issued the draft of the DLT market pilot regime, which was covering exactly the same topic. So
great. So everyone who's interested in reading some legal stuff, you can also check out the webpage of Nägele, where his the secondary market regulation stuff you wrote in English. You can read it freely access. So talking about patent, Marc, I think you're an expert on that. So explain a little bit on yourself and how you are related to patents.
Sure, thank you. My name is Marc Kaufman. I wear several hats. I'm a partner at the law firm, the international law firm of Ramon PC, and I advise several blockchain projects, many blockchain projects, and in fact, I'm here on behalf of Lot Network, for which I serve as blockchain advisor. And I think everybody here is aware of the regulatory risk and other risks related to innovating in blockchain technology. And my colleagues will tell you all about that, and you should be worried about the regulatory risk. But the one risk that I think people are not aware of is that there are over 50,000 worldwide patent families related directly to blockchain technology. 50,000 patents, patent families, in fact, that read on implementations of blockchain technology. And if blockchain technology progresses anyway through the cycle like other innovation, which I think it will, patent assertions and patent risk are going to be a big problem. And I hope we get to talk about that a little bit today also.
We will. Thank you.
Good.
So, Pelle, you're sitting next to me. Pelle, explain a little bit about Notabene.
Yeah, so I've been in the crypto space since very much the beginning, since, back when crypto was cryptography and not cryptocurrencies. And I've always been interested in identity, fintech applications of cryptography. And I think I got really excited by Bitcoin early on because the ability that I saw of it being able to change the world, create meaningful applications for regular people. And this is something that I don't think we've been particularly good at the industry. And now the regulators are kind of forcing the industry to do some of these things. So after having worked a lot with my co-founders on figuring out how to do identity for blockchains, we saw the regulators really wanted people to start figuring out who is on the other side of a blockchain transaction. Not as a big global shared Google identity database, but the parties to a transaction need to now know who's involved with that. And that's what's known as the travel rule, which is the worst name ever for a particular rule. And as a CEO of a travel rule solutions company, I wish there was another word for it. But we can get into more details later on it. But it's something that's touching every single crypto company out there, and every single crypto user will be touched by this over the next couple of years.
Yeah, travel rule is it's a strange word, but sundown is also strange. So
Yeah, or SegWit too. I think our industry is really particularly not good in finding good names, right? We should have some brand offices or something like that.
yeah, we need some standards, some standardization, and this brings us to Stefan. So Stefan, please.
Hi, good morning. Stefan Dreyer here. I'm Managing Director at ANA, which is the Association of National Numbering Agencies, an organization which is probably more commonly associated with the traditional capital markets as opposed to crypto. So maybe I should just explain. As a global industry association, we represent 120 members globally who represent key market infrastructures in capital markets. So you have stock exchanges, data vendors, central banks, regulators, and they are responsible for the promotion, implementation, and maintenance of international standards, such as the International Securities Identification Number. And as we see the evolution of the markets, there's two main topics that you can't really avoid these days. One is sustainable finance and the other is crypto. And so we see these as main drivers. So that's one of the strategic topics that I look after, really trying to understand the role of international standards as they are applied in traditional markets and how they can be transferred for the same benefit to the crypto. So as you see more tokenization of financial assets, as you see application of DLT and blockchain in various aspects of the life cycle of securities, and the emergence of a new investable investment class. So new types of assets in the crypto space. So happy to talk about the standardization topic and make sure that it keeps pace with the technology and the regulatory conversation.
Okay, let's stay with you, Stefan. So standardization, you said standardization like EASIN or WKN for security token. Is it only for security token or also for other crypto assets? I mean, if you try to also apply it a little bit to the current market, I mean, I look at Coinbase as one of the first regulated players in Germany with the license for crypto custody and crypto trading. They have big difficulties in listing their token because they are only restricted to cryptocurrencies, are not allowed to list security token. But would the standardization help for listing? So how does it help for the onboarding of the listing of the assets and for the trading? And what is the background of standardization? How does it help the market?
Yeah. So regarding the scope, particularly for ISIN, it's very much a work in progress. So for security tokens, it's something that can be applied. Here, the standard is we really look at it from a technology agnostic point of view, saying the technology shouldn't give rise to new standards. So if you have a bond, a stock, a fund, any of your traditional fiat assets that are issued in a certificate form or paper form, book entry, the fact that they're now issued on a DLT means that the same identification can be applied. And that's really the thing. It's about the unique identification of a particular asset. So the ISIN focuses very much on the asset level. We also work with other standards. There is a new standard that has come out, which is a digital token identifier, which was launched in October of 2021. And here we're working on areas of interoperability and creating a complementary standard set that can be a solution for the market. So the DTI focuses on fungible digital assets, whereas the scope of ISIN is much broader. And as I said, it's very much a work in progress. Right now, we're looking at different models for tokens which are not security tokens. So the stable coins, cryptocurrencies, et cetera, trying to come up with a centralized allocation model. So that's something that we're looking to do in the next couple of months. But then also to couple that with the DTI, which is more of a technical standard, identifying the uniqueness of a token on a particular chain.
Okay, that's interesting, and I think that's very essential to understand when you want to build up your crypto business, that standardization and ESITs and stuff like that are very needed and required for having a compliant environment. But at the same time, when you start having your blockchain, your protocol, how can patents help? Can you put a patent on the blockchain or on the protocol? So how does it work?
Well, are you asking, can protocols themselves be patented? Yeah.
Yes.
So, yeah. Well, you may have, the answer is yes. The short answer, and I'll explain. You all may have heard, if you're involved in patents at all, that you can't patent software per se, and you can't patent business methods. And that's essentially true, but that's more of a technical limitation than a pragmatic limitation. In fact, patents can be granted to, and have been granted, to protect the actual process that the various protocols go through. Now, the blockchain, the Bitcoin blockchain protocol itself was published many years ago, and thus cannot now be patented because it's not new. But as far as subject matter, it could be patented. And again, I said there's over 50,000 patent families related to blockchain technology. So you can patent it. We're seeing patents related to protocols generally, patents related to various hybrid architectures of decentralized and centralized architectures, various security mechanisms for enterprise blockchains, consensus mechanisms. Virtually every aspect of decentralized technology is being protected by patents.
Okay, and if I would be like someone who's like putting up a protocol, a blockchain protocol, so how does it work? How are blockchain protocols at risk for patent assertion, even when they're using an open source protocol?
So it's a very good question, and it's a common misconception that if I'm using open source software or an open source blockchain protocol, that I don't have to worry about intellectual property risk, and that's just not true. So you have to think about what an open source license really is. An open source license is a copyright license from the community that created that open source software. So it is just that, solely related to copyright and only from the community of creators. Any third party could potentially assert their intellectual property, whether it be copyright or patents, against users of open source technologies, and it's happened very much in the past. And what has happened, for example, with Linux software, very popular open source software, there was tremendous problems with patents, and OIN, the Open Innovation Network, was formulated to as a patent community to try to open up the patent rights related to Linux. And in fact, I'm going to give a shout out to my colleague Andy Block, who will speak tomorrow from Lot Network, and he's going to talk about Lot Network, which is in a way an analogous community that helps reduce patent risk in throughout all technologies, but specifically in blockchain for our purposes.
Thank you. So I would like to tackle a different thing. So talking about the FATF recommendations on travel rule. We have them now for some time, and how's the progress right now? Are the jurisdictions right now able to apply these recommendations by the FATF? So what are the obstacles, and what is the status, and what do you say? What are the next milestones going to be achieved?
Yeah, most major jurisdictions now are requiring it or requiring companies to implement it over the next year. So we're actually seeing pretty wide implementation right now. We have nearly 300 companies in our network right now, and most of these are working on implementing it as we speak, if they aren't already implemented. We have quite a few companies implementing it live and have been implementing it for more than a year right now. So the big challenge initially was if you are based in a small country with a regulator that requires it, how do you continue to do business in a global economy? So this is what's known as the sunrise issue, meaning how can you implement this if your counterparties aren't implementing it? But this is actually being solved right now. We've built our platform specifically to help companies solve this particular issue, and it's been quite successful. But what we are seeing is there are many, there are few key jurisdictions, such as South Korea, who is absolutely requiring it 100%. You cannot withdraw funds from a South Korean exchange without a full travel rule transaction having a back and forth exchange of information, and risk management has happened before the transaction is allowed, which has caused many companies globally to actually start implementing it before their regulator, because they're seeing they need to do so or they will lose transaction volume. So it's changing a lot. I think by the end of the year, most major exchanges are going to be live with the travel rule. But it's not an easy thing to do, because it's a very different way of withdrawing funds from an exchange that you're used to. And you can see Coinbase announced it the other day for the Netherlands, and there was an uproar in crypto Twitter about it. But it's also, I think, as an industry, we're trying to hide these things behind the scenes. But there's real benefits in the travel rule, which is really about identifying where you're sending funds to. And from the regulators, they don't care if you know where you're sending funds. They care that the exchange knows where those funds are being sent, so they can make a decision: is this going to a sanctioned institution or not? But there are benefits for end users as well. So if I'm sending funds to my son, I would much rather send it to, have verification than I'm sending funds to my son, as opposed to an anonymous blockchain address. And so what we're trying to do is actually build on ways where we implement it in a privacy-preserving way, and also bring real benefits of the travel rule to end users. But it has been a challenge for the industry to implement it, because it's many new decisions that you have to do as a compliance team. It's difficult to operationalize. So our solution's been built around solving a lot of these issues.
Maybe I can advocate. We had a small discussion before our panel this morning, and you briefly touched on that. Smaller jurisdictions started to implement travel rule, and they actually had this sunrise problem. We saw it in Switzerland and in Liechtenstein, right? I mean, in Liechtenstein, we had operating exchanges out of Liechtenstein, and then from one day to the other, they had a month or two to implement it with exactly that problem. But I think that is also the advantage of being a small country, that it can actually talk to the regulator, right, and then find a solution together, and then they issued guidance later. And I think you briefly touched on the most problematic issue a lot of people have with travel rule, and it's privacy, right? And you said that you're working on solutions, or you have solutions where it can keep my privacy and still being compliant with regulation. And I think we will, I mean, there's no question that we have this regulation that's in place, that's even it's going to be broadened, it's going to affect more and more of our transactions. That's no question, but I think that is my biggest fear, that we lose our privacy with this regulations. Yeah.
I agree, privacy, if it's wrongly implemented, can be a problem with this. But one thing to point out is that the travel rule is not a crypto-specific thing. It's something that is already implemented every time you make a payment within SEPA or SWIFT or even Visa or MasterCard, the travel rule is implemented. So when we say that this is a unique thing for crypto, it's not. It's just now the crypto industry has to implement it, but let's try and implement it in a better way than the traditional industry. I think that's the real challenge.
I totally agree that that's the case. I think the difference is that as the scope as we have it now is not for like unhosted wallet transactions. So if I don't need an intermediary, right, it's not covered yet, but that's on the table, right? And that's a different story then, or would be a different story.
Yeah, so the discussions around unhosted wallets, it's really, it's not so much about you need to transfer information because there isn't anyone to transfer information to, but it is, ultimately the travel rule is about understanding who's the counterparty, who's your customer sending funds to. Is your customer sending funds to his own MetaMask wallet? That's completely fine. So how do you prove that? Some jurisdictions require you to go in and take some additional steps to verify that. And this is where a lot of the confusion comes, sometimes from regulators, where they think, well, why can't we implement the travel rule to an unhosted wallet? So we have to do a lot of education there. But it is the core of it. What's the travel rule about? It's not about transmitting information. It's about understanding, are you sending funds to a sanctioned individual? And do you have record keeping of who did you send it to? And that's really what the travel rule is about. And those rules, from what we see, will be applied for unhosted wallets. They just have to be implemented in a better way than, you can't be naive and just say, solve it now. So the industry has to work on ways of doing it. And we're working with industry and regulators on figuring out best and safest ways of doing so. That, again, maintain privacy, which is always important.
But that's exactly the point what I mentioned in the beginning, the lack of understanding and also not the right regulation on this context, the right recommendations. I mean, the FATF recommended to apply the travel rule on crypto transactions in the same logic as you would do it on a payment with fiat, but this doesn't really work. I mean, Thomas already mentioned it, because in a crypto transaction you not necessarily have intermediaries, so it could be peer-to-peer. And so you mentioned about Coinbase, what they're now trying to introduce in the Netherlands, and talking about regulation. For those of you who know it, there was the case law in the Netherlands where they actually ruled that the law on the travel rule implementation in the Netherlands was not legal. And something similar we also face now in Germany, because Germany only put up the law on implementing the travel rule because they had a review by the FATF on the ground in Germany by the end of last year, and they wanted to look good in front of the FATF by bringing up this law. However, we do not have really the standards and the environment to comply with the travel rule in Germany, and therefore the regulator said, okay, we have now the law, but everyone who's in VESP or CASP can apply for an exemption for 1 to 2 years, just like that. So in the end of the day, so you can see that we're not there right now. And I think what you right now mentioned with patents and with standards and also with travel rule implementation, I think these are good things, but we are not there because the crypto environment is moving very fast. So I touched a little bit on Celsius in the beginning. So for those who are familiar with the Celsius incident right now, they have paused the payouts, I think from 12th of June. They have $12 billion US assets under management. We have other players such as Coinbase, who just announced that they will fire around 20% of the employees. We have funds like the 3AC fund who have invested in Luna a lot, who have liquidated, I think, 400 million of assets. So these are all things which are concerning, of course. But looking now at the lawyers in this round, at Josh and Thomas. So starting with you, Josh. If I would say from a European lawyer's perspective that these players are US players and this is all happening in the US because of a lack of regulation, would that be true or would it be not fair?
So first, I'd like to say nothing that any of us is saying is legal advice or investment advice. I don't think that within the US there's a lack of regulation. I think sometimes there's a lack of understanding as to how regulation applies, but there's plenty of regulation. And I do think, I mean, for me, there's at least 3 things I think going on, probably a lot more. But one of them is I think there's been a disregarding of the traditional financial law, like secured transactions, bankruptcy, and the like, right? Because you could be drafting an agreement on behalf of a lender, right? And you expect it to be negotiated by the other side. But what I've seen is that in instances where I've tried to negotiate on behalf of the borrower, sometimes the lender, and it could be the same, a similar lender to one where I've written a form, right, for them. They're like, whoa, we've never gotten comments. You know, and just a fundamental lack of understanding about what carve-outs you need, what protections, what things mean, because people were saying, oh, these documents, they're take it or leave it. We're not going to be able to get, you know, this interest rate if we don't sign it as is. So I think that's one, right? And also going along with that, the bankruptcy ramifications, right? What happens if you have your tokens in an omnibus wallet held with everyone else's token, right? That has a different result than if you have it segregated in some kind of a vault or something like that. And also you have to read the documents. I think a couple of other quick things. One is, you know, they often say, or it's often said, it's not business, it's personal. In our space, it's business and it's personal. And I think a lot of what we see, not all of it, but much of what we see is driven by personalities, and sometimes personalities don't like other personalities, and so there are wars on Twitter, there are all kinds of things like that. There are pressures that happen behind the scenes, and I think that's really important to take into account. Sometimes people want certain people to lose, right, because they don't like those people. And our space, while I feel like it's the center of the universe, it's still small enough that that can happen, right? I mean, it can happen throughout the world, but I think it's something important to bear in mind. Sometimes when things are said repeatedly, you have to remember, why are they being said? What is the goal of someone repeatedly saying this? And then the other thing, and again, there's a lot more than this, but I think the shorts, right? People coming in, not even necessarily from our industry, but they see something moving in a direction and they go at it and they just keep shorting, and then you'll hear people saying, oh, I shorted it all the way to the bottom with a sense of pride, right? Like, we're supposed to be this ethos of togetherness, you know, collaboration, decentralization, and often when that starts happening, I think what we see even from hedge funds and others outside of our space is every man for himself.
So, coming to you in a second, I just want to put the finger around. So you were talking about bankruptcy and ring fencing the client assets from the trading assets. I mean, I'm talking right now about Coinbase. So I was working with Coinbase in the past. I helped them in Germany to get the license. And I remember when we had the workshop with the German regulator, it was mentioned that the client assets or the crypto assets of the users who trade on Coinbase are separated from the assets which Coinbase is using for their own purposes, or for prop trading purposes, for shorting, for other things. And then suddenly, in the SEC report, they said, no, it's not protected, it's at risk. If Coinbase is going to default and there may be insolvency, the assets are not protected. And then I talked again to Coinbase and said, oh, yeah, it's not really true, and SEC forced us to bring out that report. Now we're working on that to clarify this. But I would say, again, this is again a classical example for a lack of understanding of where are your assets. I mean, we have the saying, not your keys, not your assets, and everyone would say, yeah, it's true. So how does it really work for someone who's not really familiar with SEC law or US law? And just to bring it, like, really put it like in two sentences, what is happening right now with Coinbase, and are the assets really at risk?
So I can't speak openly. Obviously, I work for a global law firm. We have a lot of clients. But what I can say is, you know, in general, if you look at secured transactions law, which is where this derives from, right, there are certain instances in which you could say, for example, okay, I'm going to assume for purposes of Article 8 of the UCC, the Uniform Commercial Code, that something is a security. Different, right, from, for the SEC purposes, something is a security. Now, if you were to say, okay, it's a security, then maybe you can be in a position, if you have a whole bunch of assumptions and those assumptions all happen to be true, that you're acting as a securities intermediary. And so maybe there is some kind of protection in certain instances. In other instances, and I'm not talking specific to any particular trading platform, wallet, exchange, etc., But in other instances, you may have, like I mentioned, omnibus wallets where, yes, people's accounts will be segregated at the end of the day, but during the trading day, it's all in one wallet, right? And so you have to really understand, okay, for something that happens there, where do I fall? If there's a secured lender or something like that, am I all the way back at the end of the line, right? And you have to imagine, you may think, oh, those are my digital assets, right? But you could be an unsecured creditor, coming after, trying to come for what's left.
Yes, so, okay. So, I would still say what I said in the beginning. I think that the regulation and understanding in the US is not there where it's supposed to be when it comes to crypto assets. But looking at Liechtenstein, and I know that big players in Liechtenstein also like Bittrex, and Liechtenstein, I think, has a benefit of having two things. One is having their own blockchain act, and the second thing, which is very important, Liechtenstein is within a European Economic Area, and therefore they are going to comply and apply European crypto assets law, like soon to be the MiCA, the Markets and Crypto Assets Regulation. So would you agree what I would say the place to be for starting a crypto asset business is maybe Liechtenstein?
I'm kind of biased to that question, but I will answer your other one, and I think I will add add my comment here to if, and I'm not talking specifically about the US, but I'm seeing like the global landscape of regulation wherever I am. I try to understand a little bit the landscape in Europe at least. And your question was if there's a lack of regulation. We heard specifically like the challenges, for example, the US have. If and that's one general rule if for those who don't know and who are not lawyers, but if you have a specific law, at least in the civil law frameworks, which is specifically for one kind of or one specific topic, and there's a general law which covers a lot of topics, also this one a little bit, always the specific law has to be applied, right? So in general, if you have a blockchain act and you have like a general law, always the blockchain act is applicable. And we started exactly that discussion in 2017 in the work group because we said, yes, we have a lot of laws which could be potentially applicable, right? But we don't know how courts will then actually apply them. We don't know the outcome. And we got a lot of feedback from the industry. Yes, they want to comply with even compliance with all of the rules, but just tell us how and why and what do we have to do. And that's why we said, okay, we first of all differentiate between crypto assets and financial instruments, because financial instruments, securities, is something different than a crypto asset, right? And then we differentiate between services which are provided by central intermediaries and things which happen fully decentralized. Maybe we don't need any licenses. First of all, we cannot license anyone because there is nobody to tackle, right? There's no person, individual, which is really providing these services. And I think that comes back to your thoughts on, you have to understand first, right? You have to understand the potential of these technologies. You have to understand also the risks, and then you hopefully come up with good regulatory approaches. So I think, yes, if you have a tailored comprehensive regulation which is tailored for this industry, I think that is beneficial because the entrepreneurs know where they are, the regulators know how they should apply these laws, right? And then it's anyway an ongoing process. You have to constantly evaluate and actually make it better. And I was at a panel some weeks ago, and there was one person rephrasing this duck sentence. So if it walks like a duck, if it smells like a duck, it's a duck. And we said, okay, but sometimes it's really a challenge to find out if something is a security. And we have the same challenge in Europe, but it's not that of a big problem because we have a rather good idea of what is a security and what is not. And so we talked about that, and then in the end, he said, if we tear apart the duck, so we have to really look very, very closely. If we tear it apart and look at very closely what it is, how it was constructed, what are the licenses or the claims and whatever, we can tell you if it is a security. And I said, okay, so basically you have to kill the duck first, and then you know what it was. So that shouldn't be the approach, right? That's my take on that. And if Liechtenstein is the best place, I think there is no best place. It really depends on your like which products and services you are wanting to offer, and what are your target markets, right? And every jurisdiction has pros and cons, but at least it's worth to have a look at.
Yes, and I think I have to apologize to Josh and to the US visitors. Of course, I had to do this David versus Goliath approach to take like the US market and Liechtenstein and try to give some handicap to the US and try to push Liechtenstein. I mean, what I think all can agree on that is that the crypto industry is complex and there is no right framework and no right approach right now. However, we have to really try to do our best to apply the right approach. And what I read last time about the US, what is very interesting, this comparison between Sam Bankman-Fried and JP Morgan. For those of you who are good of history, when we had the crash like 80, 90 years ago in the banking industry, JP Morgan helped out all the banks in the US market, those who really were in need, because JP Morgan thought that if he helps the banks with his private funds and they go through the crash, and then it will help to really keep the US banking and capital market live. And I think something similar Sam is right now doing. Can you a little bit explain on that, Josh?
Sure. I mean, I'm sure he's doing a lot of things that none of us know as well. But recently you may have seen that there was a large secured loan, right, extended, 250 million, I believe, to BlockFi. Now, I don't know the ins and outs of this deal, but one of the things that's super interesting, at least what's been reported in the press, so take this with a grain of salt, is that apparently he was the only lender that was willing to allow the customer assets to go ahead of his interest. So, I mean, that is really, I think you can read a lot into other things, like, I won't go into the details of what's been reported, but I do think that that does show faith in the industry and caring for customers, right? Say what you will, but not taking, having a large loan like that and not trying to take a first lien position, that's really unheard of. But as for whether he's going to become the new JP Morgan, I mean, I think JP Morgan's probably trying to become the new JP Morgan too, right? I mean, with all, like, many of us, I'm sure, represent a lot of banks as well as digital asset native companies. I think it's really interesting to see as well what is being reported just in the press, again, without verification of it, but just allegedly Goldman Sachs is trying to find a group or pull a group together to help certain DeFi lenders. So I actually think what's going on is incredibly interesting. It shows also, I think, just going back to Sam for a second, obviously he knows the industry, he knows the players, and so I think that positions him very well for this.
Yeah, great. So I would like to ask each of you to explain within 1 minute how your topic, like patent, could help right now in the current crypto environment to make the environment better. So maybe you start, Marc, and then we go through.
Okay, I'd be glad to. So this is a topic, the good patent versus bad patent topic, and how whether patents foster innovation or hinder innovation is a topic that we, or at least I, could discuss all day, but I promise not to. So yeah, patents, when used properly, can foster innovation, and the blockchain space will be no different. And that's a big part of why I'm here, and a big part of what Lot Network is about allowing the proper use of patents for true innovators to share and be compensated for their innovation without hindering innovation by having unnecessary patent litigation. And that takes, just like blockchain development, it takes community. And it's all about patent community. Lot Network is a patent community. There will be patent pools, but it takes participation of the entire community. And I recommend to everybody here that you look into that, because you have the choice right now whether you want the blockchain space to be the subject of unnecessary patent litigation or the subject of sharing innovation in a way that allows others to utilize your innovation and you to utilize their innovation in a community-like atmosphere. Is that under a minute?
Great.
Okay.
Great. Pelle, so please.
Okay. So far, the last 10, 12 years, and particularly the last 10 years, crypto, most of the conversation we have, it's about traders, trading, people who are buying, and there's all the leverage trades, all of those kinds of things. I think what we have an opportunity to do now, as we're going into this crypto winter, as some people call what we're entering now, is to build new applications where we tie things out into the real world. And that's really what the travel rule is, even though it's implemented because of a different purpose, but it gives us in the industry a tool to build for new use cases, whether it's payments, e-commerce, any of these kinds of use cases when you're trying to figure out how do we grow this industry. So I think it's really exciting to be part of that and help push crypto forward.
I will make it short. I think that it's somehow similar to patents. Regulation could foster innovation or hinder innovation. So I dedicate my time to Josh and Steven.
Oh, thanks. Well, I just want to say something about crypto winter. So because that term seems to lead to a lot of other terms, I feel like we should change it to like a crypto hurricane, right? We can even name them, right? They come and they swirl things up and then they go, right? As opposed to sticking around for way longer than a season. So that's what I would say. I think we need to rebrand that.
We are back at branding again. We need
Exactly.
more marketing.
Exactly. Yeah. Thank you, everyone. I pass to you.
Sure. So we talked a lot about the kind of fast-paced evolution of the crypto space, and I think one thing that we see on the Anna side is that it's going to take us a long time before we're in a fully tokenized economy. So we've still got traditional financial assets over here, we've got crypto assets, and how do you marry and bridge that? And I think that standards can help do that. Some of the comments here about classification and taxonomy and treatment, securities, is it a security, is it not a security? There are other suites of standards as part of this ISO standard universe, such as classification of financial instruments, which will help to identify and help answer that question. Obviously, the lawmakers have to make the determination first, but these become the tools, and that's why it's important that this standardization topic is kept at the same peer level as the technology and the regulatory conversation.
Thank you, Stefan. Thank you, everyone. And I think we are at the end of our panel, but you can approach each of the wonderful speakers at the event. I believe you are all staying for the next 2 days. I would like to thank you all, and please applause for the speakers.
And applause for the moderator.